Welcome back to PCA Deep Dive, a service of the Pennsylvania Chiropractic Association. Sometimes the most consequential legal cases aren't the ones that dominate headlines. They're the ones that quietly redraw the rules for billion-dollar industries. Today's episode focuses on the New York Court of Appeals decision in Geico versus Mayzenberg. If you're a healthcare provider, an insurance professional, or simply someone who depends on fast care after an accident, this ruling matters. This case isn't really about one provider or one insurer. It's about guardrails, it's about due process, and it's about preventing the claims process from becoming a weapon instead of a system designed to deliver care quickly and fairly. Let's get into the details.
Sometimes the most exciting legal cases, they aren't the ones that make front-page news. They're the ones that kind of quietly reshape the rules for these multi-billion-dollar industries. And today we're diving into a case that does exactly that. It's like a mix of a legal thriller and a really fundamental policy lesson, one that dramatically redefined the boundaries between massive insurance companies and state regulators.
That's right, and this deep dive is all about the New York Court of Appeals ruling in Geico v. Mayzenberg. And look, if you're a healthcare provider, an insurance professional, or even just someone who relies on getting fast care after an accident, this decision is, well, it's key. It tells you where the power truly lies and, maybe more importantly, where it absolutely ends.
Okay, so let's set the stage. The facts that started this whole thing are frankly pretty shocking. It involves an acupuncturist, Igor Mayzenberg, who was allegedly running this huge, sophisticated kickback scheme for years.
And the scale is what's so incredible here. It's what takes this from a simple dispute to, a monumental conflict. We're talking between 2015 and 2017. Mayzenberg was accused of orchestrating a $390,000 kickback operation.
Wow.
Yeah, he was allegedly paying unlicensed people in cash for patient referrals. And that eventually led to nearly $4.9 million in billed services. So the insurer, Geico, they look at this and they just say, hold on, this is clear fraud, we're not paying.
And that's the core paradox we're going to get into, because the headline isn't really the misconduct itself. I mean, that's obviously serious, but it's the court's definitive ruling on what an insurer can't do, even when they suspect this kind of blatant, almost criminal behavior.
Exactly. The court's ruling basically settled a turf war. It answered the question, who gets to decide if a practice is legitimate? Is it the private insurance company holding the checkbook, or is it the state regulators who are actually charged with professional oversight?
Okay, so let's unpack this. Our mission today is to pull out that critical, bright line distinction that New York's highest court established. It's a line designed to, preserve due process for licensed professionals, but also stop insurers from weaponizing the claims process against its own goal, getting accident victims paid fast. Let's start with the misconduct itself. How exactly did this scheme allegedly work?
Well, the alleged scheme was almost brazen in its simplicity. It was a classic, if massive, illegal kickback structure. Mayzenberg, the licensed provider, was accused of paying unlicensed people for steering patients his way. What seemed to shock the court, based on the sources, was just how informal it all was. Very undocumented. People would allegedly just call him up, say how much they were owed for referrals, and he'd pay them in cash.
So from Geico's perspective, this looks like a slam dunk, right?
Right.
You're a provider operating on illegal referrals, violating all these rules of professional conduct. So the nearly $5 million in claims must be tainted. What was their legal strategy?
Their strategy was very direct. They sought to deny all the outstanding no-fault claims from Mayzenberg. Their argument was that because he violated professional conduct rules, the practice itself was illegitimate. And therefore, the services, just weren't covered. The fraud basically invalidated everything.
And that makes intuitive sense. I mean, I think anyone running a business would think, if the whole operation is based on illegal activity, why should I have to pay for it?
And that is where it gets really complicated. The Court of Appeals ruled, and they ruled with overwhelming clarity, it was a 6-1 decision, that the insurer was acting beyond its authority. So the answer, counterintuitively, is that even with all that evidence of misconduct, the insurer absolutely cannot make that final call on their own. So when you look at that 6-1 decision, the court drew this really fundamental line. Insurers, they said, do not have the authority to unilaterally decide that professional misconduct has occurred and then use that as the basis to deny a claim.
So who gets to play judge and jury then?
That power belongs exclusively to state regulatory bodies. In New York, that's the New York State Board of Regents. They handle licensing for most professions, including acupuncturists. It's the Board of Regents, with its own investigators and hearing processes, that has the sole power to revoke a license or rule on misconduct.
And for our listeners, the Board of Regents isn't just some small committee. It's a major governing body. They have the whole structure and due process built in to handle this stuff. But let's get into the why. Why did the court feel so strongly about stripping insurers of this power, even when faced with what looks like multi-million-dollar fraud?
The court pointed to a very specific historical concern: preventing the weaponization of the claims process. You have to remember, New York's no-fault system was created back in the 70s for one main reason:
Right.
to get accident victims fast compensation for injuries without the delay of a lawsuit.
Right, so you get paid quickly, you get your care, and you don't wait 3 years for some court case to resolve.
Precisely. And the court saw that if insurers could deny payment based on their own internal suspicion of misconduct, they would be incentivized to use that as a weapon. They could just demand endless documentation, hold payments for months or years while they investigate, and basically grind the entire system to a halt.
So the fear was that letting Geico be the judge here would just open the floodgates. Every insurer could just cry fraud whenever they didn't feel like paying a claim, and that would completely destroy the speed and efficiency the law was built on.
That is the core of it. The court saw the administrative obstruction, the delay tactics, as a greater threat to the system than the misconduct of this one provider. They were protecting the process itself.
I think it's fascinating that the majority was 6-1. I mean, that's almost unanimous. This is just a really deep concern. Did the one dissenting judge say anything about, just letting fraud run wild?
Yeah. Absolutely. The lone dissent worried that this ruling essentially forces insurers to pay out millions in claims they know are generated by illegal activity just because the state bureaucracy hasn't caught up yet. It's a real policy challenge. The dissent is basically asking, are we telling Geico to just pay $4.9 million in tainted claims to preserve due process for this one provider?
That is a tough question. You have to
Yeah.
sit with that for a second. You realize the court isn't necessarily trying to protect the acupuncturist. They're protecting the fundamental structure of the law itself and the rights of all licensed professionals.
And this is where that great analogy from the sources comes in. It really helps it all click. The court described the insurer as the traffic cop.
The traffic cop.
Okay.
So they can see the bad behavior like the kickbacks and they can report it.
Right. They have a responsibility to report it. They can write the ticket.
But they can't just take your driver's license on the side of the road and decide you're never driving again.
That's the key. That's the perfect way to put it. The power to seize the license, to revoke standing, that is reserved for the judge. And in this case, the judge is the state regulator, like the Board of Regents, and only after a full hearing, the insurer reports, the regulator judges. You can't blur those roles.
But doesn't this ruling just tie insurers' hands completely? I mean, we don't want our listeners walking away thinking insurers are now powerless against fraud. There has to be a line where they can still fight back.
There is, and it's a major crucial exception. The court carved out a very precise situation where the insurer does still have the authority to deny claims immediately. And that is if a licensed provider has effectively surrendered control of their practice to people who are unlicensed.
Surrendered control. That seems like the key phrase here. It's what separates Mayzenberg's kickbacks from, say, outright structural fraud. So what does that actually look like? How does an insurer prove that without, crossing the line back into judging misconduct?
This is that bright line we were talking about. The court is making a distinction between bad professional behavior, which needs a regulator, and a fraudulent administrative structure where the licensed provider is just a ghost.
Can you give us an example?
Sure. Imagine a shell clinic. So on paper, a licensed physical therapist, let's call her Sarah, owns the practice. But in reality, all the actual administrative control has been given to, say, her unlicensed brother-in-law. The insurer investigates, and they find evidence that the brother-in-law is signing the big checks, setting patient quotas, hiring and firing clinical staff.
Okay, so he's making all the core business decisions. Sarah's just there to sign charts.
Exactly. That is evidence that Sarah has surrendered administrative control. The licensed professional is just a placeholder. In that situation, the insurer can deny the claims immediately because the entire entity is fundamentally illegitimate. It doesn't matter if Sarah was also doing kickbacks on the side.
So the court is saying Guyco couldn't deny Mayzenberg's claims because he, however corrupt, was still the one in administrative control of his own practice. He was making the decisions, even if they were bad ones. But if he had just, lent his license out to some criminal group that was running the whole show, then the insurer could have acted.
That's it, precisely. The bright line is between policing professional behavior, which needs the Board of Regents, and stopping these clear structural frauds, which the insurer can tackle right away.
Which means legitimate providers, even if they're under investigation for some kind of behavioral issue, are protected from having their income just shut off by an insurer acting on a hunch. That's a pretty serious layer of due process.
It's a huge shift in power. Insurers now have to use the official channels, report their concerns to the state, and let the state do its job and make the final call. And if we connect this to the bigger picture, this ruling is really about restoring balance to the no-fault system. For providers, it means they can expect to be paid until due process is finished. They can keep their doors open, keep treating patients. That's critical.
And this isn't just about New York no fault, is it? This Geico ruling feels like part of a much broader pushback we're seeing from courts against insurers overstepping.
Oh, absolutely. The trend is pretty clear. Courts are pushing back when insurance companies try to, make up their own rules, whether it's redefining what's medically necessary or, like in this case, trying to take on a regulatory role they were never given by law. Judges are basically saying, your desire to cut costs does not give you the power to just bypass the state's own systems.
So for policymakers, this case kind of exposes a real challenge. Everyone agrees fraud is a problem. But how you fight it can't come at the expense of due process or, critically, speedy payments for accident victims.
And here's the new pressure point this creates. By giving all this authority back to the Board of Regents, the court has put a huge burden on that agency. These complex fraud cases, which insurers used to handle internally, now have to go through a state bureaucracy that might not be equipped for a sudden flood of referrals.
Right. So the court solved one problem, the weaponization by insurers, but may have created a new bottleneck problem at the regulator.
It creates a new pressure point for sure. The state authority now has to deliver timely and effective justice, or the whole system could risk gridlock from the other direction.
Okay, so to summarize the key takeaways from Geico v. Mayzenberg, we have a very clear division of labor now. Insurers have to pay claims even if they suspect misconduct, and they must report those concerns to state regulators, like the Board of Regents, who get the final say.
And the one singular exception is when a professional has totally surrendered administrative control of their practice. That's when the insurer can act immediately. That distinction behavior versus control, that's the real nugget of knowledge to take away from this deep dive.
This really is a landmark case that any licensed professional in a no-fault state should know about. It really affects their rights and their stability. It's definitely going to shape litigation for years to come.
Which leaves us with a big question for you to think about. If the court successfully stopped insurers from weaponizing claims denials, how much funding and scrutiny is needed to make sure that the state regulatory agencies themselves don't become a new, slow, bureaucratic weapon against providers who are just waiting years for a decision? Can you have both efficiency and justice? Something to mull over.
Thanks for listening to this deep dive into the boundaries of authority.
We'll see you on the next deep dive.
Today's deep dive showed how the Geico versus Mayzenberg decision drew a clear line. Insurers can investigate and raise concerns, but they cannot replace regulators or deny claims based on suspicion alone. It's a ruling that reinforces due process, protects licensed providers, and preserves the purpose of no-fault systems. The PCA Deep Dive series is produced by the Pennsylvania Chiropractic Association to help make sense of complex legal, regulatory, and policy issues affecting chiropractors across the Commonwealth. If you're not yet a member of the PCA, we encourage you to consider joining. Reach out to your local elected officials and support the PCA PAC. Together, we are fighting for your right to practice chiropractic. If you enjoyed this episode, please like, follow, and write a review. And if there are topics you'd like us to cover in future episodes, contact the PCA using the email address in the show notes. Until next time, stay curious, stay engaged, and stay informed. Thank you for listening to the PCA Spinal Chat Podcast Deep Dive Series.